The marriage is one of the most important topics which the liars usually have to consider. In the ordinary parlance, nikah and marriage have two different meanings. In our society, first the nikah is solemnized, then the marriage is performed. It usually happens that nikah takes place in a month and then the marriage is solemnized after a few months later. So there is a distinction between marriage and nikah in our customary life. The people usually ask whether it is a date of nikah or it is a date of marriage. But when we consider the Hanafi law of marriage, we don't find any two distinct meanings to these words. So, in the legal term, marriage and nikah are one and the same thing. If we say that nikah has been solemnized, it means marriage has taken place. And when we say that marriage has solemnized, it shall mean that the nikah has taken place. So there is no distinction between marriage and nikah. If we talk that the man has remarried, it means that he has entered into a nikah. So wherever the word marriage is used in the Hanafi law of marriage, it means solemnization of nikah. And whenever the word nikah is used under the law, it means that marriage has been solemnized. So far as the law is concerned, marriage is a civil contract. And when we say that it is a civil contract, it is also thought that it is sacrosanct. But whether or not it is sacrosanct, it is altogether immaterial. The material thing under the law is that it is a civil contract and it fulfills all the ingredients of a civil contract, meaning thereby that there is offer, acceptance. Now the question is that there can be no contract without consideration. If the marriage is solemnized on the basis of offer and acceptance, then where is the consideration? The answer is simple, that the dower is consideration of marriage. So the dower is also fixed. When we talk of the marriage and say that it is a civil contract, we mean that it fulfills all the requirements, all the ingredients, and all the essentials of a valid contract. Meaning thereby that a marriage is necessarily based upon proposal and acceptance, proposal by one party, acceptance by the other parties. It sometimes happens that parties themselves do not propose and accept. In that situation, they may appoint anybody to propose on her behalf, and the man may also appoint anybody to accept on his behalf. So the proposal of and acceptance may be completed not only by the parties themselves, but by their appointed and authorized persons as well. So it usually happens that the wife is sitting in the house, the man is sitting outside. They appoint a person who goes to the wife and asks her to enter into a marriage contract. And when after she gives her proposal, the man comes back and asks the husband that I had asked the wife and she is ready that a nikah should be solemnized. So on the basis of that, it happens that the husband accepts it. So on the offer and acceptance and the fixation of the dower, the marriage is solemnized. So under the law, the marriage is a civil contract and it fulfills all the requirements of a civil contract. Now the next question is that our society, it depends upon the people. If there is no person, there can be no society. So what is the object of marriage in the society? Why a marriage should be entered into between the two persons, a male and a female? So what is its object? So the objects under the law are two. Number one, the procreation of children. And second is to legitimatize the children. After marriage, if a child is born, he shall be presumed to be legitimate. But if there is no nikah and the child is born, he shall not be a legitimate child, but shall be known as bastard. And a bastard child has got no value in the society. So in order to legitimize the children, the marriage is solemnized. So in short, we can say that the object of marriage is the procreation and legalization and legitimatization of children. Now the next question is as to who has the capacity to enter into a marriage. The law is very simple on the subject. A sound mind may enter into a nikah. A major may enter into a nikah. So meaning thereby that everybody of sound mind and who has attained the age of majority may enter into a marriage contract. But now the question is, can there be no nikah of a minor? The answer is no. A minor can also enter into a marriage contract. But how? Marriage is contracted on behalf of a minor. We may say that a minor and a man of unsound mind may be validly contracted in marriage by their respective guardians, meaning thereby that if there is a body of a minor and the father wants that he should be entered into a marriage contract during his lifetime, so he chooses a girl for him and he allows the man who is reciting nikah to enter into it on his behalf. So the guardian may enter into a marriage contract on behalf of a minor, and if there is a person appointed guardian for a person of unsound mind, that guardian may also enter into a valid marriage contract on his behalf. So the capacity of marriage is not dependent on the age, is not dependent on the soundness of mind. The man of unsound mind and the minor may also enter into a marriage contract, but through their respective guardians, not themselves. Because we have already stated that marriage is a civil contract, and a contract cannot be entered into by a minor and a man of unsound mind. So when a man is of unsound mind, he cannot enter into a contract. If there is a minor, he cannot enter into a contract. But here in this case, the contract may be performed by the guardian. So the capacity of marriage means the authority to enter into a marriage contract. So this contract is as much valid as a contract entered into by a person himself. So under the law, Hanafi law of inheritance, we have gone through the definition of marriage and we find that there are certain essentials of a marriage. What are those essentials? Number one is proposal. Number two is acceptance. But if a boy and a girl offer and accept the marriage contract, how it shall be presumed that they have entered into a marriage contract? So the law in its own wisdom says that there should be evidence thereof. So under the Hanafi law of inheritance, when we talk of essentials of marriage, we say that proposal, acceptance in the presence of two males or one male and two females. So it is one of the essentials of a marriage contract that there should be two witnesses under the Hanafi law of inheritance, under the Hanafi law of marriage. But what is the effect of non-presence of witnesses? Meaning thereby what is the effect of absence of witnesses? We shall consider it at a later on, that if the witnesses are not available, then whether the marriage is valid or not. But at this moment, we are studying the essentials of a marriage. So meaning thereby that essentials of marriage are proposal, acceptance in the presence of two male or one male and two females. So there is a consideration as well, and that is dower. The fixation of dower is also considered necessary for the purpose of a marriage contract. So when we enter into a contract of marriage, we find that there are three classes of marriage. Number one is valid marriage, number two is irregular marriage, and number three is void marriage. So these points have been considered by the superior courts in various judgments. So I am going to give you one of them so that you may be able to understand the classes of marriage. A marriage may be valid or irregular or void. Marriage may be valid means Islamic Hanafi law recognizes it as a सही marriage, सही निकाह. तो जो सही निकाह है उसको वैलिड मैरिज कहते हैं. और दूसरे नंबर पर है इर्रेगुलर मैरिज. इसके मानी है फासिद. फासिद जो है वो बातिल नहीं है, जबकि वॉइड मैरिज जो है वो बातिल कहलाएगी. इसका मकसद ये हुआ कि हमने मैरिज की तीन क्लासेस रिकॉग्नाइज की हैं अंडर द हनफी लॉ ऑफ इनहेरिटेंस. नंबर वन वैलिड, नंबर टू इरेगुलर and number three void. So this point was discussed in an authority PLD 1968 Lahore, page 587. I would like to read the same before you so that you may be able to understand the real sense of the classes of the marriage. The Hanafi jurists have divided the marriages into three classes. Number one Sahi, number two Fasid, number three Batil. When we talk of these in the English language, we say valid, irregular and void, depending upon their validity and effect. In case the marriage is free from all sorts of defects and infirmities, perfect in every respect and absolutely valid, it is called Sahi. It conforms with all the requirements laid down by the Shara for the marriage, that is, the existence of the proposal and acceptance, presence of the witnesses, a competency to contract, fitness of the subject of marriage, and so forth. But a marriage in which there is a deviation, howsoever trivial or slight, from the rules of Shara is not altogether nugatory. These defective marriages are classified into the two degrees. These two categories are, in case the defect is of a radical and vital nature, the marriage may be nugatory and void ab initio. So to say, in the eye of law, it is no marriage at all. It produces no results, and in it the words of the proposal and acceptance were uttered in vain. Such a marriage is called batil or void. However, in between the two is a third class of marriages. It is neither perfectly valid nor altogether void. In such a case, the irregularity or defect in the marriage is not fatal to its existence, and some of the consequences of a Sahih marriage will be found to flow from it. A marriage of this kind is called fasid or irregular, invalid, vicious, and defective. The Sahih marriage shows that the quality of goodness or excellence exists in it, and not only the essence is good, but its equality is also good. However, in a bath or void marriages, in the essence and the quality are both bad. But in a fasid marriage, although the essence is good, the defect lies in its quality. A batil marriage is unlawful in itself, but in a fasid marriage, the unlawfulness consists in something else. So, we saw under this authority that it has divided the marriage into three classes. So, every class has its own consequences. So far as the valid marriage is concerned, it is free from every defect, and it is as perfect as required by Islamic law of marriage. And so far as the void marriage is concerned, it is unlawful, it is not recognized by law, and it is not sufficient to legitimatize the children. And any child born as a result of this void marriage, this kind of marriage, as a result of a batil marriage, the boy shall not be entitled to inherit anything from her father or his father, as the case may be. But so far as the irregular marriage is concerned, it has certain effect. And for example, we see that marriage with a woman undergoing iddat. Suppose a marriage exists between a man and a woman, and a man dies. So she is bound to stay for a specific period, and that is called iddat. And if she is divorced, even then she has to wait for some period, and that is called period of iddat. So during the period of iddat, the purpose of iddat is that we should be aware of the fact whether or not she is pregnant. But if she enters into a marriage contract during iddat, what will happen? The law says that this marriage is not void. In the earlier judgments of the Lahore High Court, at some time the High Court was of the opinion, the Honorable High Court was of the opinion that this marriage is void. But later on, this view prevailed that it is not void, but it is irregular. So, irregular marriages may be regularized under certain circumstances. We shall see in the next lecture as to how the irregular marriage is regularized and what is the effect of an irregular marriage. So far as the irregular marriage is concerned, it is very much clear that if a person enters into a marriage contract with a person who has not completed the period of iddat, the marriage is irregular and the children are legitimate, not illegitimate. So we have seen these factors, that these are the points which are to be considered at the time of entering into a valid marriage contract.